Working of the Supreme Court at Calcutta. Then we were seeing the jurisdictions. First was the civil, criminal, and then ecclesiastical jurisdiction. Merits. There was a definite improvement in jurisdiction. Judges were having a knowledge of a law. Judges were served honestly. These are the merits. Then the non-merits of the ecclesiastical jurisdiction. Then now we are going to see the first case, trial of Raja Nandkumar. So here Nandkumar, a Brahman, was a big zamindar and a very influential man in Bengal. Raja Nandkumar was conspired and he was tried as a guilty of taking bribery. This case was considered as a judicial murder. Very important question. The question is asked, what is judicial murder and which case is related to the judicial murder? Supreme Court had responsibility to send mercy application to the British Crown or a king in council, but in Raja Nandkumar's case, the mercy application was rejected. As Chief Justice, Sir Elijah MP was the best friend of the Warren Hastings, and this case was tried against Warren Hastings. So, in favor of Warren Hastings, Sir Elijah MP given the judgment against Raja Nandkumar, and it did not allow him to send the mercy plea. Raja Nandkumar brought the cases like Warren Hastings was taking bribes. First, the allegations were made by the Raja Nandkumar on the Warren Hastings. Then Raja Nandkumar was given the title Black Colonial, and there were two groups in the Governor Council, Governor General in Council. It was means there were two groups were formed in favor of Raja Nandkumar and in favor of Warren Hastings. It was Governor General Warren Hastings and the Councillor Barwell constituted one group, and the councillors Francis, Clavering and Monson constituted the other group. Raja Nandkumar was encouraged by the majority to bring the certain charges of bribery and corruption against Warren Hastings before the council. In March 1775, Nandkumar gave a letter to Francis, a councillor, containing certain complaints against Warren Hastings. He stated that the Warren Hastings accepted from him as a bribe more than 1 lakh rupees for appointing his son Guru Das as a Diwan. The letter contained another charge against Warren Hastings that he accepted from the Munni Begum as a bribe of 1,50,000 rupees for appointing her guardian of the infant Nawab. The letter was presented in the council. It was not presented in the court. Then in the meeting, Monson, means councillor, opposed that the Warren Hastings could not be seated in his own case. So a criminal cannot be a judge in his own case. The council said the charges against Warren Hastings are true. So the council directed him, means Warren Hastings, to deposit 3,54,105 rupees in the treasury of the company. So the case was given, means here the Warren Hastings rejected to give this amount. Then the case was given in the hands of Supreme Court, and here Warren Hastings charged Nandkumar as a liar. Means in first case Nandkumar charged Warren Hastings for taking bribery and corruption, and when the case was given in Supreme Court's hand, that time the Warren Hastings charged Nandkumar as a liar with the two others, Fox and Radhacharan. These three people were prosecuted by the Warren Hastings in the Supreme Court for bribery and forgery. Then Supreme Court punished Fox for bribery, and in May 1775 charges of forgery were presented on the Raja Nandkumar by a native Mohan Prasad. Means Mohan Prasad is the person of Warren Hastings, and he charged Raja Nandkumar for doing forgery. The Supreme Court gave judgment against Raja Nandkumar for Forgery Act 1728, which was passed by the British Parliament in India. Here Raja Nandkumar is not given a single chance to send his mercy plea to the Privy Council or a king in council. He was given a capital punishment, so that's why this case is considered as a judicial murder. This is the case of Raja Nandkumar.